In 1956, a man who had paid into Social Security for nearly 2 decades opened a letter telling him the checks were stopping. He hadn't committed a crime. He hadn't lied on a form. He had done something that was perfectly legal at the time he did it. He took the government to court, and the case he lost is still the law today. It decides something you have probably never thought to ask: the money taken out of your paycheck your entire working life. Is it actually yours? His name was Nestor. He came to the United States from Bulgaria in 1913 and stayed more than 40 years. From December 1936 to January 1955, he worked in covered employment. He paid in. His employers paid in. 18 years of contributions. In November 1955, he qualified for old age benefits. The checks began arriving. As far as he understood it, he had bought something, and it had finally come due. But there was something in his past. From 1933 to 1939, Nestor had been a member of the Communist Party. Here is the part that matters. Membership in the Communist Party was not a crime. And in 1939, the Supreme Court had ruled that once someone had left the party, past membership alone was not enough to deport them. Nestor left the party the same year. Congress closed that door the following year. In 1940 and again in 1950, it made past Communist Party membership a deportable offense, reaching backward to people who had already walked away. The Supreme Court had already blessed that move, twice. In 1952 and again in 1954, it upheld deporting people for Communist Party membership they had ended years before. The reasoning was a piece of legal logic that is going to come back in a minute. Deportation, the court said, is not punishment. It is a civil consequence. And the constitutional ban on punishing people for conduct that was lawful when they did it simply does not reach it. In July 1956, Nestor was deported. And then a second thing happened, the thing this video is actually about. A provision Congress had added 2 years earlier, Section 210, cut off Social Security benefits to anyone deported on certain grounds. 18 years of contributions stopped paying out. One correction to the version of this story you will usually hear. He did not lose everything. His wife stayed in the United States, and under the statute she remained eligible for the spousal benefit tied to his record. What ended was his own. Nestor sued, and in 1959 a federal district court agreed with him and struck the provision down. Its reasoning was the intuitive one, the one most people would give. He had worked, he had paid. What he had built up was, in the court's phrase, an accrued property right, and the government could not simply erase it. Then the government appealed to the Supreme Court, and to understand why he lost, you have to go back 20 years to a problem that had nothing to do with him. When Social Security was created in 1935, nobody was sure it was constitutional. The federal government setting up a nationwide pension system was, at the time, a genuinely open question. So, the program was built carefully, not as insurance, not as a contract. It was built as two separate things that only look like one thing from the outside. On one side, a tax on wages. On the other side, a benefits program Congress writes the rules for. 2 different laws doing 2 different jobs. In 1937, the Supreme Court upheld it on exactly that basis. Justice Cardozo wrote that the money collected goes into the Treasury, in the court's words, like internal revenue taxes generally, and are not earmarked in any way. Not earmarked, meaning there is a record of what you paid in, but there is no pot of money sitting somewhere with your name on it. What you pay in this year is not saved for you. It goes out this year to people collecting now. Your future benefit is not the money you paid. It is a promise Congress wrote down. Franklin Roosevelt understood the politics of this perfectly. The reason contributions came out of your paycheck at all, he told an aide, was so that people would feel they had earned a right to collect, and so that no politician would ever dare take it away. That was a political strategy. It was not a legal guarantee, and the courts never treated it as one. Which brings us back to Nestor. On June 20th, 1960, the Supreme Court ruled against him, 5-4. Justice Harlan, writing for the majority, said the problem with Nestor's argument was what it would do to the program. To build in what he called accrued property rights would rob Social Security of the flexibility and boldness it needed to adapt. The court drew a sharp line. A person covered by the Act, it said, holds a non-contractual interest. You are not in the position of someone holding an annuity, who paid premiums and is owed a defined payout under a contract. It is not that kind of arrangement. But the court did not say Congress can do anything it likes. It set a floor. A change violates due process if it amounts to, quoting the opinion, a patently arbitrary classification, utterly lacking in rational justification. That is a low bar for the government to clear. It is not no bar. 4 justices thought that was nowhere near enough. Justice Black dissented, calling this both an ex post facto law and a bill of attainder, Congress singling out a disfavored group and punishing them by legislation without a trial. Justice Brennan, joined by Chief Justice Warren and Justice Douglas, dissented too, but on the ex post facto ground alone. He expressly declined to decide the attainder question. They lost. Section 202N stood. Ephraim Nestor had been deported to Bulgaria, and after the case ends, the historical record simply goes quiet. What became of him is not recorded in the sources. Now, this ruling gets quoted constantly, usually badly. So, here is precisely what it does not mean. It does not mean a clerk can flip a switch with no process at all. If you qualify under the law as it stands, you are owed notice and a chance to contest a cutoff. But how much process and whether it comes before or after the money stops depends on the benefit. For welfare, the court has required a hearing first. For Social Security disability, it ruled that notice and a chance to respond is enough up front. The fuller hearing can come after your check has already stopped, with back pay if you win. It also does not mean the money is unprotected once you have it. Federal law shields Social Security benefits from ordinary creditors and most legal judgments, even after the money lands in your bank account. Not from everyone. The IRS can still reach it, and so can a child support order. But in some ways, your benefits are harder for a creditor to take than your ordinary savings. What it does mean is this: Congress can change the rules going forward for everyone, and no one can sue on the theory that they already bought the old deal. And Congress has. In 1983, it raised the full retirement age from 65 to 67 and started taxing benefits for higher income recipients. Millions of people who had been paying in their whole lives had the terms changed on them lawfully. It runs the other direction too. In 2025, Congress repealed 2 provisions that had been reducing benefits for public workers: teachers, firefighters, police. And more than 3 million people got money back. The same power that takes can also give. And this is not old law that quietly stopped mattering. The court reaffirmed it in 1971. It used it as the governing test in 1975. It applied the same reasoning again in 1987. Flemming against Nestor has never been overruled. It is the rule today. This case is used as ammunition by people who say the whole system is a mirage, and by people who say it is just a tax and you were never owed anything. Both are reaching past what the court actually said. What it said is narrower and stranger. You have earned something real, and Congress wrote it down, and Congress can rewrite it. Whether that is a betrayal or just how a program that has to last a century stays alive, that part is not a legal question. That one is yours.